got out of here pretty quick last month, didn't we?
Boy, I don't remember. It seems like it.
Yeah, I
Like
was trying to tell
9:30-ish.
George.
Yeah.
First time,
Good morning, everyone. I'd like to welcome you to the December 15th, 2014 Assessment Appeals Board for Tulare County. Today, sitting on the panel is myself, George Azunian, Matthew Graham, Lynn Fowler. Alternates 1 is Lance Morris. Alternate 2 is William McKinley. First item on the agenda is comments from the board. Comments from the staff?
Yes, sir, Mr. Chairman. I'm not sure the assessor's going to announce this again, but Christy was not present last month. She did win the election for Kings County Assessor, so this is her last meeting with
Congratulations.
our county. Thank you. Or condolences. So we've certainly appreciated your service in Tulare County, and we know you'll continue that in Kings County, and we're sorry to lose you.
Thank you. I've appreciated working with all of you.
Also, sitting with me today is Jennifer McNichols of the resource team. I think you've seen her sitting out in the audience, but this may be the first time she's been on the dais with me. Another attorney on our team. We're trying to get some more people up to speed so that if I'm absent, then we can have somebody just slot right in. And then at our last meeting, the board asked me to take a look at what was going on in other counties in regard to encouraging people to show up for hearings once they've said they're going to. And we do have some preliminary information on that. As Mr. McKinley remembered, there is a provision in the Kings County rules where they pay a hearing deposit fee when they apply. And then if they withdraw at least 30 days before the hearing, they get that back. Or if they show up for the hearing, they get it back. And that's for all application other than those involving owner-occupied single-family dwellings. And I didn't check to see if they had an application fee besides. You know, we have this $30 processing fee for handling the application. So I haven't asked Kings County if that has succeeded in discouraging the kind of thing that we see under our rules, where this one particular agent has a habit of saying he's going to come for the hearing and then withdrawing. So I don't know if it would solve that problem or not, because the actual applicant would pay that fee, and so it still wouldn't bother the agent any to withdraw late. It would, just cost the applicant. They wouldn't get their deposit back. So I don't know if it would help any or not, but it's certainly at least one model, and we're still looking to see what other counties are doing, and I'll be checking on that and getting back to your board later.
Fee for finding a fact.
We do charge a flat fee for that.
And in effect, they can make that determination all the way to the time of the actual hearing?
Right. We make them pay it before the hearing starts.
Okay.
But that's any time up to then.
Okay. Anything else?
So that's all I had.
Thank you. Okay. Mr. Assessor.
Ms. Grunwald happened to steal our thunder, so...
No other comment?
Outside the fact it has been a privilege to have Christy, certainly the board can anticipate some changes coming up. We will have staff, much like council, coming in to try to learn the duties that she's leaving, and so just expect some changes in the near future.
Okay, good. Okay, going to agenda item 2, which is a withdrawal, and on to agenda item number 3 is Frank and Adriana Leindecker. Are they here?
Yes.
You'd like to step forward? And this is a personal property matter, so the applicant will present their case first. If the clerk will read in the application numbers,
I'll do the swearing in.
and,
You want me to swear them in?
and swear them in, yes. The assessor and the applicant.
Go ahead and hold up your right hand. Do you solemnly swear or affirm that the testimony you are about to give in the matter now pending before the Assessment Appeals Board is the truth, the whole truth, and nothing but the truth?
I do.
Please state your name.
Rick Rosales.
Greg Gruen.
Okay, I'm going to go ahead and read them.
Yes.
Application number 2013-00082, APN number 048-030-008-000.
Okay,
Excuse me, Mr. Chairman, it's an escape assessment?
yes.
Is the assessor conceding that they should go first?
I don't have a problem going first.
The rule is where all
Where
the
the
information has been
assessment,
provided.
the assessor goes first.
Yeah.
Okay.
It was an escape assessment that was generated before the bill was due, so it was part of the original bill. So I don't know if that affects the determination of who goes first or not.
I'd have to go look, but as far as I know, whenever you do an escape.
Okay.
Okay, then why don't the assessor go ahead and present your case then?
Okay. Here's my copy.
Candace.
Good morning, Chairman. Good morning, board members. The assessment appeals number is 2013-00082. It affects the 2013 lien date. The applicant's name is Frank and Adriana Leindecker. The assessor's parcel number is 048-030-008-000. The total taxable value on the tax roll for 2013 was $3,687,736. The assessor's opinion of value is the same. The applicant's opinion of full cash value is $3,256,226. The subject property consists of a dairy residence and acreage for farming. The street address is 9001 Avenue 360, Visalia, California. The equipment consists of fixed dairy equipment, movable equipment, farm implements, horses, and carriages, carts, wagons, henceforth to be known as carriages. A breakdown for your viewing is in Exhibit A, and that basically outlines the assessable values for 2013. The approach to value that was used, since the applicant is appealing the accessibility of the carriages, the assessor will focus only on the carriages themselves and their valuation. The carriages are considered antiques by the assessor's office because of their craftsmanship, age, rarity, beauty, and excellent condition. The carriages are stored in a temperature-controlled environment that conserves their condition. In determining valuation, the previous factors were considered, and no depreciation was applied to arrive at fair market value for the carriages. Article 13, Section 1 of the California Constitution states, unless otherwise provided by this Constitution or the laws of the United States, all property is taxable and shall be assessed at the same percentage of fair market value, and you will find in Exhibit B, Section 1, a copy of that explanation. The carriage's fair market value was determined to be the applicant's original purchase price, which was derived from the applicant's depreciation schedules. The value decision was based on the carriage's excellent and like-new condition, which would be similar to when originally purchased. Assessor's opinion of value. For the 2013 lien date, the assessor's office enrolled a value for the collection of carriages that the applicant owns. As previously mentioned, the carriages are stored in a temperature-controlled environment, and the collection consists of approximately 30 carriages. The assessor's office has treated the assessment of the applicant's carriages as assessable vehicles. Per Section 670 of the Vehicle Code, a vehicle is a device by which any person or property may be propelled, moved, or drawn upon a highway, excepting a device moved exclusively by human power or used exclusively upon stationary rails or tracks. And there's a copy of that description in Exhibit C per the DMV Section 670 Vehicle Code. For pages 28 and 29 of the Assessor's Handbook 504, to be assessable, there is no requirement that vehicles be used for business purposes as required for other types of property. Based on the Vehicle Code and court decisions, a device could be illegal to operate on the highway and exempt from vehicle registration, but may still be a vehicle. And you can find that literature in Exhibit D on pages 10 and 11 in your packet. And I've highlighted the sections that are pertinent to my debate here. Okay. For Revenue and Taxation Code 401.3, the assessor shall assess all property subject to general property taxation on the lien date as provided in Articles 13 and 13A of the Constitution and any legislative authorization thereunder, and that's in Exhibit E. Revenue and Taxation Code 224, Tax Rule 134, and California Constitution Article 13, Section 3 detail what types of property are exempt from personal property taxation, and you'll find that in Exhibit F, and it's referencing different R&T code sections, tax rolls, and there's a listing per the California Constitution of items that are exempt. It's pretty extensive. I'm not going to go into it, but it's there for your viewing. Carriages do not fall under any specific category of property that would be exempt. Section 224 specifically states that personal effects do not include vehicles held or used in connection with the trade, profession, or business, so held or used. Per Article 13, Section 2 of the state Constitution, the only authority in the state that would have the power to exempt such equipment is the state legislature, and that's in Exhibit B, Section 2. And it's there for your viewing and reading. In addition, per the applicant's website address, www.liondecker.com, there are pictures of carriages being pulled by Frisian horses, implying the carriages are used for business promotional purposes in conjunction with the applicant's horse breeding business. In the history section of the website, the narrative furnished describes the antique coaches, wagons, and carts as vehicles. If you turn to Exhibit G, page 22, on the applicant's website, they specifically describe the carriages as vehicles. I've highlighted that portion for you. I know it's pretty tough to read with the background being in black, but it's on page 22. You found it, Mr. Zinian?
Yeah.
The assessor kindly asked the board to deny the applicant's request based on the grounds that carriages are assessable personal property. Carriages should not be considered vehicles and not household furnishings or personal effects. Our assessment of the carriages would be analogous to enrolling an assessment to someone who has a collection of antique tractors or farming equipment. Such equipment would also not be exempt on grounds they are personal effects collected as part of a hobby. And that concludes my presentation.
Okay, does the board have any questions of the assessor? I have a question. Now, in effect, and I don't, according to the law that you have presented here, if someone has an antique sewing machine, is that taxable?
That would be considered a personal effect, a household good.
Right. Now,
Unless it's being used for business.
Okay. But in effect, what it amounts to is these carriages, because you can wind up taking them up on the road, would be subject to taxation.
Correct.
If they were not going up and down the road, would they be taxable under the law you just presented to us?
If they were not considered a vehicle, there would be a good argument that they wouldn't be exempt as a personal effect.
So if I have a Patek Philippe watch that's $2 million, is it taxable?
I would say no.
If you use that watch to advertise my business,
Yes.
then it would be. Gotcha. I understand.
If you turn to page 16, and I'm sorry, I said I concluded my presentation, but in the middle of the page, it says personal effects is a category of personal property which includes such items as money kept for household use, clothing, jewelry, tools, hobby equipment, and collections and other recreational equipment. By statute, it does not include boats, aircrafts, and vehicles.
Right. I understand. Any other questions of the board?
These carriages, are they licensed? I mean, through the DMV?
No, they are not licensed. In order to be, normally licensed vehicles are exempt if they pay a licensing fee as part of the registration, but because they are not licensed and they're not paying registration, there's no component of a licensing fee they're paying to the DMV, which would subjugate them to exemption.
Because I see these carriages and these types of antique farm equipment and used as decoration as all the time. So I guess the question is, how do you define the difference between being stored in a temperature-controlled area versus it being a decorative lawn? I don't see how you make the fine line between the two. Is it just because they use them as business?
Well, the applicant is stating they're not being used for business. Our argument is that they are considered vehicles, and they are being used in a portion of his horse breeding business for promotional purposes.
I understand.
So
it's an interesting connection.
Exactly.
How many of these are there?
Approximately 30.
30 carriages.
Correct.
They're all being used for business?
You would have to ask the applicant that question.
But your position is that it's not because they're being used for business, it's because they are a vehicle.
No, my position is that they are considered vehicles, therefore they are accessible.
And the decision does not rest on the fact that they are used in equipment.
It appears per their website that some of the carriages are being used for promotional purposes for the horse breeding business. So therefore, some are being used for that portion of his business.
But you're not treating those any differently than the
Correct.
other?
Correct. We're treating them all the same.
So if the carriages were in this controlled environment and they were bolted to the floor so they would never move, would they still be, what would they be considered then?
I guess they would not have to have wheels. Therefore, they wouldn't.
Even though they're anchored to, I'm just saying, if they're physically not going to be moved or be used as a vehicle at any point, are they still considered vehicles?
I think the argument could possibly be changed, and the argument could be said that they are not considered vehicles. It would be considered by the assessor's office.
Okay.
It would be the same argument if you took the wheels off your car, because cars really, you do pay property tax on your vehicles too, but it's paid through DMV rather than the county.
So if I have an old Ferrari,
and
I'm thinking of Ferris Bueller, there's a car in the in the glass building. It's not supposed to be driven, right?
Right.
And it's probably not licensed regularly through DMV. So is it a collectible or is it a vehicle? Of course, he drove it, but that's beside the point.
Yeah.
It seems to be an important question.
Yeah.
Right.
Yeah. Going back to my Patek Philippe
Antiques
watch.
are accessible too. Antiques are an accessible item, unless they're shown in a museum a certain number of times a year. There's rules about an antique as far as making it something that's not accessible, and that would have to be on display for the public.
Ask a question. On these antiques, as time goes by, don't they appreciate in value?
Appreciate it.
They could. We don't have any market data in terms of the carriages appreciating in value, so therefore we value them at cost. Cost equal.
They're buying this equipment and refinishing it?
I would assume so, but you would have to ask the applicant that question.
Yeah, we're going to get there in a minute. Anything else from the assessor?
No, I'm done.
Okay. If the applicant will present your case. And the way that we're going to do this is that basically the assessor makes his presentation, you make your presentation, we're going to go through some cross-examination and then a summary, and we're done. So if you can go ahead and make your presentation, we'd appreciate it.
Okay, thank you. Thank you for the opportunity to argue. And we have Frank Leyendecker here, son Gerben, and I'm their CPA. And our presentation is going to basically be substance over form. The form that Mr. Rosales is talking about is something that's very general, and we think in this specific instance, these are antiques, they are works of art, and they are not used in the business.
Let me just clarify something. Mr. Leyendecker, do you remember ever meeting me? Because I think I've met you once before, not related to anything here. It's not an issue with me. I just want to clarify it. I think you own another piece of property that I had met you regarding that property 5, 6, 7, 8, maybe 10 years ago. But do you remember me? No. And you may not be the gentleman that owns the property next to on Betty Drive. That's you. Yeah, I talked to you about that property once. It had nothing to do with this case. So I'm just clarifying the fact that I don't have an issue. If you don't have an issue, I'm going to continue hearing it.
Is that acceptable to the assessor?
Yeah,
Yes.
It was you owned some property on Betty Drive that has some commercial applications, mostly empty, and then you also own the trailer mobile. Okay, yeah. So I did meet you once at your ranch. So I'm just clarifying that. Not an issue with the assessor?
There's no issue.
Okay, very good. Then we'll proceed. Okay.
Okay. What I'd like to do is quickly read the letter. If it's okay, you haven't had any time to really go through it in any detail, so if it's okay, I'll just read it. It should take about 3 minutes.
Okay.
Okay, we're writing to support the position that the horse carriages and most of the horse tack should not be considered taxable for personal property tax purposes. Facts and circumstances are Frank Leyendecker's in the business of breeding Frisian horses through the means of artificial insemination. He owns several stallions, buys and sells a few of these stallions. In the past few years, a few, maybe one, maybe none, maybe two in a year. It's not a regular back and forth. It's mainly the breeding through AI that the revenue is generated. The only source of income from the breeding business is a sale of semen from the stallions to various customers throughout the world. Semen is collected and sent overnight express or other means to other owners of the Frisian horse network, the purebred network. He also has a collection of antique horse-drawn carriages that total approximately 30 in number, stored in a climate-controlled, secured barn. Carriages purchased between years 1980 and 2001 were put on the depreciation schedule and depreciated. Those are approximately 14 carriages. The carriages purchased from 2002 to present are recorded on the depreciation schedule but are not depreciated. The depreciated carriages were reported on Form 571 until year 2013, where they were removed from the form. The assessor's office has added back all 30 carriages and issued an escaped assessment in the amount of $431,310. No depreciation has been deducted on the carriages since year 2001. And if I can interject that, it's the hobby loss rules. If you have a loss on a hobby 3 out of 5 years, There's no revenue generated from these carriages. The Leyendecker family uses them for parades. You may have seen them in the Rose Bowl parade. All of this is done at no charge, no cost reimbursement, so forth and so on. Sorry, I'm kind of nervous, so I'm getting kind of shaky. Just a second. You aren't really an imposing group, but I just take a breath. Okay.
Let me just reiterate. This is an informal hearing.
Right.
We're just people like you.
Well, I'm a bean counter, and I feel passionate about this, and I want to convince you of our position in the worst way.
Right ahead.
So, okay. The 13 carriages shown on the depreciation that were never depreciated but were listed there to track the purchase dates and amounts. They were never included in the tax returns. For the last 20 years, the IRS, I'll go through this real quick. For the last 20 years, the IRS does not want a detailed depreciation schedule. They just use the Form 4562 to summarize what the depreciation expense is in total. And I've attached a copy of their 4562, which just shows a depreciation expense amount. The fixed asset module in their tax preparation software allows us to book things like land, carriages that you don't take depreciation. You just track the date of purchase and the cost so that you can, 20 years from now, figure out what you paid for this, piece of land or a carriage or any other type of investment. So since, in paragraph 6, or point 6, since 2001, the carriages were not part of the breeding business, nor were they used in conjunction with this business. With the advances of artificial insemination, Frank Leyendecker decided to focus his business on the breeding only. All carriages are now used for city parades, weddings of friends, family. Valley Hunt Club of Pasadena usually invites Mr. Leyendecker to the annual Rose Bowl parade. These participations in weddings and parades are done at no charge or reimbursement for expenses. There's also no advertising on these carriages. There's no business use connected. That copy from the website is our off-the-shelf pictures of a carriage in Holland. They're not a picture of Frank's carriage. Again, there's no business use connected with the antique carriages. The whole Leyendecker family participates in this hobby, including the grandchildren. All this work is for fun, community support, and to display the craftsmanship of an era gone by. So maybe we can go to the last page right now, and we'll get back to the finish. But where the photographs are, this is photograph number 1. Is in the building, the climate-controlled and secured building. We're standing right in the middle, looking at a center aisle. There's carriages on the right-hand side. There's a carriage in the center, and there's carriages on the left. Photograph 2 shows, again, we're halfway into the building. On the left side, the row. Photograph 3 shows the right side of the row. And if you flip it over, you'll see photograph number 4 is one with his hand-painted with the 4 seasons of Holland, which is rain, rain, and more rain, usually. But you'll see that the craftsmanship there is just a demonstration of something that you just wouldn't want to take out of the and have even in the sunlight for an extended period of time. Picture 5 is the Edinburgh carriage. That is, you can see how well done and taken care of this is. You just don't take these carriages outdoors very, very quickly. And the last one is to show some of the craftsmanship. On photograph 6 is a white funeral carriage. All of this is carved wood. It looks like there's rope hanging there. That's not really rope, that's wood. And they're quite unique. They're like museum pieces. Okay, then the crux of the matter, or the final conclusion then for us is using publication 29, says personal effects, household furniture, and hobby equipment and other personal expenses are exempt. Then we go to conclusion number 2, talking about works of art. The value of the work of art owned by the artist, that really doesn't apply. But the bold part, works of art, antiques, and other decorations used in conjunction with a business and are not otherwise exempt should be assessed. Well, if we say these antiques are not used in conjunction with a business, they should be exempt. So that's our presentation.
Okay. Does the board have any questions of the applicant's presentation? I have a question. Has all of this collection ever generated any money? No. In other words, it's never generated any revenue from prizes, or it's not a. This is something that you're doing as a collection that is a hobby, and you've never generated any money from it.
It's my hobby.
No.
It's educational. I learned the kids how to harness a horse and put it in the front of the wagon.
Do you ever have any school tours?
Yes.
Okay, and they come through and they look at all this stuff as historic.
Yeah.
Okay, but you've never presented any of this to for a application for a prize that you've won.
No.
Okay.
You'll see the ribbons in the building, and if you enter in a parade or you go in a parade, you will get a ribbon. Okay, so, and Frank sticks them all up there, and I mean, this year he's been in Reedley, Dinuba, Tulare, where they took a brass lantern. They ripped one off the back of your carriage. Visalia goes on, and it's all done the family does this. And
now the assessor's made a comment, and I'm going to let him reiterate his point that you've got this thing for the promotion of the breeding business.
The business started in the 80s. Frank had a couple of horses, bred the horses, and were going to raise the horses to be purebred Friesian horses. But from the time the colt drops to the ground, it takes 4 years before they even start evaluating that animal, and most of the time, there's something wrong. It isn't quite right, so they won't give it a thoroughbred Friesian classification. Now you have a pet, okay? But they pull a carriage real well. Well, Frank's in his 80s. He just wants to do the artificial insemination, sell the semen throughout the world to other Friesian horse owners that have the time, money, and effort to really raise these animals to be a purebred class.
So in other words, basically, whether they're pulling one of these carts or photographed with the cart is incidental to the fact that they're used for breeding.
Correct.
Okay. Now the assessor can go ahead and rebut what they've presented.
If you look at page 2 of their presentation, towards the bottom, where under section 1, where it says supporting conclusion based on facts and circumstances, the publication that they quote, the second sentence says this exemption does not include vehicles with the value over $400. So I think this would apply to the carriages that we have assessed.
Repeat that again for me.
The publication that they're referencing, publication number 29,
Okay.
it describes personal effects. And the second sentence says that this exemption does not include vehicles with the value of over $400, and that would apply to their carriages. So the exemption therefore does not, the exemption as a personal effect, as hobby equipment, would not apply to the carriages because they're considered vehicles.
I see. Any other comment, questions of the board?
Would you go back over the description, or where you showed the description of what a vehicle is?
Sure. It's going to be in Exhibit C. And it's per the DMV Code Section 670. It says a vehicle. It says a vehicle is a device by which any person or property may be propelled, moved, or drawn upon a highway, excepting a device moved exclusively by human power or used exclusively upon a stationary rail or track.
What does the vehicle code have to do with the taxation code?
The vehicle
Property
code
tax.
defines what a vehicle is, and if a vehicle is not registered with the DMV and is not paying licensing fees, it is accessible by the assessor's office. It's accessible personal property.
Still going back to my same question.
Yeah.
Why does the vehicle code affect property taxation?
If you turn to page 10 of my handbook,
Okay.
I'm going to read under vehicles, vessels, aircraft, and manufactured homes. Vehicles, vessels, aircraft, and manufactured homes not on permanent foundations are also classified as personal property. Therefore, the vehicle is personal property. They are accessible personal property to the owner, whether the owner is an individual, a business, or otherwise. To be accessible, there is no requirement that they be used for business purposes as required for other types of personal property. It matters because the vehicle, by definition, is personal property. We do not assess it if it's registered with the DMV because they are paying in lieu taxes as part of the registration.
Can I add something?
Sure.
Per the State Board of Equalization, LTA, letter to the assessor 9444, it states that neither the Revenue and Taxation Code nor the Code of Regulations includes a definition of vehicles for purposes of this exemption. Accordingly, it is necessary to consult other authorities to define vehicle, and then they specifically list Section 670 of the Vehicle Code, which is basically what he's already presented to you. I think what this case comes down to is whether this is actually a vehicle or not, because vehicles are not exempt from taxation in any manner. You know, they're either taxed by DMV, taxed by the counties. So we're trying to present the case basically that this is a vehicle, and the applicant is presenting the case that this is a hobby. So this was a tricky one, and that's why it's being presented. But our contention is that this is something used to propel or move persons or property.
You have an argument as to why this shouldn't be treated as a vehicle.
Yes. The glaring argument that I see is what is the difference between a highway and Main Street in Visalia, Main Street in Dinuba? Was that considered a highway? It says that may be propelled, moved upon a highway. When I think of a highway, I think of 198. Of course, that's a 4-lane, but there's a 2-lane highway. The Dinuba Highway. You would take a horse-drawn carriage on a highway nowadays. I think that if it's used, a city street may not be considered a highway. And I would say then, I mean, you could hook a rope on a wash machine and hook a horse up to it and put wheels on the wash machine, and it'd be a vehicle pulling it down your driveway.
Would it normally not even be allowed to be on that road unless it was a special event? such as a parade.
Cordoned off and
Right.
because there's a huge safety factor.
Right. It's not allowed to be on the road, basically.
Correct.
Right. Yeah.
Correct. Unless you're Pennsylvania Amish,
Amish,
and then
yeah.
they do that.
Is it true that horse-drawn vehicles are not allowed on some highways in the state?
I am not familiar with that portion of the tax law, so I would be unable to answer your question.
Well, like the 99 highway.
Mm-hmm.
You don't even have to wind up having a carriage for them to exclude you from the highway because you can't go fast enough. Like a golf cart.
Correct.
Or a go-kart. Okay? You can't run that up and down the highway because it doesn't go fast enough. Right?
Correct.
The Amish, for instance, have to have very special laws in Pennsylvania to allow them on the road. And I can't picture California letting a horse-drawn vehicle on a normal street.
I don't know what the exact definition of a highway is, if it would just be a street in a city, or how extensive or how big the road has to be and how many lanes it would have.
Mr. Fowler,
Yes.
you were on this committee specifically. Do you have questions of either assessor or the applicant?
This is a tough one because it looks like a hobby to me.
Okay.
I also redo antique tractors, and that is my hobby. So I know what you're doing with this thing. So it's a toss-up one way or the other.
Mr. Graham.
Yeah, I agree. It seems like a hobby to me. I mean, being that fact that it doesn't produce any income, it's used and it really is. I mean, you can tell by these pictures, it's preserving the past, and I would say it's a hobby in my opinion.
Any cross-examination questions of the applicant from the assessor?
The only thing we kind of Googled real quick, the definition of highway, and it's saying a highway is a way or place of whatever nature publicly maintained and open to the use of the public for purposes of vehicular travel. Highway includes street. So just to throw that in there.
Okay. Okay, any further questions? Then we're going to go ahead and go to summary and allow the assessor to summarize his case first.
Thank you, Board. We feel that the carriages are accessible based on the fact that our definition of them is that they are vehicles per the DMV code and thus accessible per California Revenue and Taxation Code. We feel that the applicant has provided a good argument for their case, but we feel nonetheless that we have correctly assessed their carriages as vehicles, and we hope you can take that into consideration when you make your determination. Thank you.
And the applicant, can you summarize?
Our summary is would be that the carriages are not vehicles. The carriages are not used on highways, despite the definition of Google. The carriages are not used in the business. They were tracked on the depreciation. Half of them were tracked on the depreciation schedule just to record purchase date and amounts. They were used when the business was in a different manner from 1980 to 2001, but they are now no longer used in the business and is just used for hobby purposes, and that they should be exempt under the antique and hobby exemptions for this personal property. Thank you.
Okay. I'm going to bring it back to the board and ask the members that are sitting whether we'd like to make a determination or take it under advisement. Mr. Graham.
I'd say make a determination.
Fowler?
I'm with him, Mr. Graham.
And I agree. Do I hear a motion to settle this matter at this level, stage? Do I hear a motion?
I'll make a motion that we rule on this hobby horseless carriage assessment. I rule in favor of the hobby.
Applicant. Okay, Mr. Graham?
I would second that.
Okay, we have a motion to find in favor of the applicant. All in favor signify by saying aye. Aye. All opposed? Hearing none. Your application is approved as a hobby instead of a business-related personal property.
Thank you, Board. You made us have a Merry Christmas. And same back
And the
to
same
you.
to you.
Thank you.
Does the assessor still want findings, or are you okay without findings?
We're okay without findings.
Okay, thank you. So the
Very
record
good.
will reflect that the assessors waived their standing request for findings.
You know, when we find cases and come to a conclusion for the applicant at the hearing, it's very gratifying. Thank you very much. Thank you, Board. Okay, we look like we have a number of applications. Well, the one here, next one is application or agenda item number 4, Appellate Hospitality. We've, I think, heard this before. Is there anybody here representing them? If you'd like to step forward. Okay. Good morning. And good morning. There's an issue of timeliness here.
I believe they just want to get a
Continued.
postponement.
Yes.
Okay, you'd like to get it postponed, and the issue then is that was your response
It was 1 day late from what I...
1 day late, okay?
Mr. Chairman.
So that's now the issue that we're talking about.
It's a little different than that. They actually used their matter of right postponement for this particular case in November. So underneath our local rules, he would have to appear before the board to request an additional postponement. So we're actually working on the case, and we have no problem with the postponement, but it just maybe stage it properly. It's not a timely issue. It has to be here in order to request the board's allowance of the postponement.
So we have an issue regarding the 1 day issue late. And Mr. Fowler, Mr. Graham, any comment regarding that? Well, let me ask the question. Why were you a day late?
I'm here to represent the applicant. I believe I was not the one that filed or the paperwork. This property belongs to, we're tax representatives nationwide, and the client belongs to someone in the District of Columbia. We are here to present so they won't have to fly all the way from Washington to request a continuance.
Okay.
I was not handling the paperwork myself.
So I'm going to go back and ask the panel members, do you have an issue with giving them a postponement and allowing them to present their case? Let's say, when are you asking to present your case? January?
I believe so.
That would be fine with you. Okay.
I'm for it. I think they should.
You have no issue?
I don't have an issue with that.
Okay. Do we need a formal motion allowing them the
That would be
additional
helpful.
time?
That would be helpful to the clerk, yeah.
Okay.
To grant the postponement to January.
Right. Then I'd like to
That's acceptable
entertain
to
a motion to
Is that acceptable
grant
to
the
the
applicant a additional month.
I'll make a motion that we grant Apple 8 Hospitality an additional month to come before this board to present their case.
And Mr. Graham?
I'll second that.
Okay, we have a motion and a second to, we're then going to postpone this for a month, correct?
Right, right. And just to be clear, we won't send a new notice.
Okay, do I hear a motion?
Is that all the clerk needed? Okay.
I didn't hear that. I didn't hear.
Oh, we normally send a 45-day notice for a hearing date. I was just clarifying that we wouldn't be doing that here.
So we could do 30 days.
Well, they've waived it on the record, so.
Okay. Hear a motion?
I'll make a motion.
Second.
I have a motion and a second to postpone this to our January meeting,
Which, for the record, is January 26th.
January 26th.
It's the fourth Monday in January rather than the third because of the holiday.
Don't be late.
9 a.m.?
Second time around, you may not be as lucky.
Thank you.
Okay, we have a motion. All in favor signify by saying aye. Aye. All opposed? Motion carries. You're postponed till January 26th.
Thank you, Mr. Chairman.
You're welcome. Okay, now we're to agenda item number 5. 6, 7, 8, and 9. Are those all withdrawals?
That is correct.
Okay. Okay, we're going to consider those under the withdrawal calendar. And that brings us to agenda item number 10. Russell Fagan, is anybody here representing Mr. Fagan?
Looks like the same outfit that canceled all the other ones.
Okay. Okay, so regarding agenda item number 10, we're going to deny this for non-appearance. Do I hear a motion to consider agenda item 10 as a non-appearance item?
I'd make the motion.
Okay. Do you have
I'll
a second?
second it.
You have a motion and a second to deny agenda item 10, Russell Fagan, for non-appearance. All in favor signify by saying aye. Aye. All opposed? Then agenda item 10 is denied for non-appearance. Okay, regarding agenda item number 11. Now this is an item that was not confirmed. Are you representing the assessor?
Yeah. Oh, no, sir. Representing the taxpayer.
You're representing the applicant.
Yes.
Okay? And what was? Let me get this door closed. Okay, then what is our issue regarding your response untimely?
This is the first request, and we had a change in personnel, and I just happened to be looking through the file, fortunately, last week, and came upon the notice, and it was not entered by our staff in our computer for tracking. So I'm here today to request a continuance to whatever meets the assessor's agenda.
Are you prepared for January 26th?
Yes, I am. I'm prepared today as well.
Assessor?
We would be fine with that.
Okay, so...
Quick question.
Sure.
I represent Hydrite. Is this Hydrite Chemical off of Clancy Court?
Yes, it is.
I represent them.
So you wouldn't be able
real estate.
to
I'm
take any action?
Yeah.
Okay, so our next alternate would be
Morris today.
Mr. Morris. Okay. Then would you have an issue with them continuing till January 26th?
No.
I have none.
Okay, do I hear a motion?
I'll make a motion that we move this to January 26th.
Second.
Madam Clerk will list it as a postponement.
What's this?
Oh, technically a postponement because we
postponement.
haven't started.
Postponement,
the hearing.
okay.
Okay, postponement. Okay, we have a motion for a postponement to January 26th on the agenda item number 11. All in favor signify by saying aye.
Aye.
All opposed, motion carries. So that one will be heard by myself, Mr. Fowler, and Mr. Morris.
Great. Thank you
Okay.
so much.
You have your continuance.
Thank you.
I beg your pardon. We will not send it, just to let you know, Mr. Fagan, we won't send a new 45-day notice. You'll just expect to show up on the 26th.
Okay. Regarding agenda item number 12, 13, and 14.
We do have a stip on 14,
Oh, a stipulation. Okay.
12 and 13.
Mr. Sesser, do you have any other information regarding agenda item number 12 and 13?
On item number 12, Padma LLC, they sent in an email yesterday from their attorneys saying that they had a family emergency and would not be attending. They hadn't previously confirmed attendance anyway. So that's kind of the situation with them. We've also sent them a request for information with no response.
I think additionally, it'd be important for the board to know that we're actually currently reviewing the value of that property under a previous assessment appeal. So what Mr. Padma is appealing here is the actual reduction in value he's already receiving. He's at 40% of what his actual factor base year values are. So
what do you think we should do with this?
Denied for non-appearance, and then let him come back and request.
Yeah.
Okay. Then how about number 13?
That one, we've sent a request for information as well with no response from the applicant. We haven't heard anything from
So
the
we should
applicant,
deny both 12 and 13 for non-appearance.
in our opinion.
Okay. Any other comment from the board? Done. Do I hear a motion regarding agenda item number 12 and 13, denial for non-appearance?
I'd make it.
Nobody here from either one? Okay.
I'd make a motion to deny for non-appearance for 12 and 13.
Okay, we have a second?
I'll second.
Okay, we have a motion to deny agenda item number 12 and 13 for non-appearance. All in favor signify by saying aye.
Aye.
All opposed? Motion carries. Okay, we have a stipulation for agenda item number 14. Is the assessor prepared to read the stipulation into record?
Yes, I am.
Okay, go ahead and proceed.
The applicant is Golden West Restaurants, Inc. For the 2009 lien date, the application number is 2012-00768. Assessment number is 800-243-256-000. The fixed improvement value is $1,388,300. The personal property value is $15,265. The net taxable value is $1,403,565. For the 2010 lien date, the application number is 2012-00769. The assessment number is 800-243-256-000. The fixed improvements value is $1,451,479. The personal property value is $15,439. The net taxable value is $1,466,918. For the 2011 lien date, the application number is 2012-00770. The assessment number is 800-243-256-000. The fixed improvements value is $1,220,907. The personal property value is $13,422. The net taxable value is $1,234,329. For the 2012 lien date, the application number is 2012-00771. The assessment number is 800-243-256-000. The fixed improvements value is $1,151,529. The personal property value is $35,312. The net taxable value is $1,186,841.
Very good. We have a stipulation read into the record. Is there any other comment? Hearing none, do I hear a motion to accept the stipulation that's been read in by the assessor?
I'd make the motion to accept the stipulation.
Have a second?
I'll second it.
Okay, we have a motion to accept the stipulation. All in favor?
Question.
Yes.
As Lance and I were the ones on the original vote, should we be doing a second vote?
Oh, yes, sorry.
Yes.
The panel should be Mr. Ozuni and Mr. McKinley and Mr. Morris.
On that issue. Okay, then
since
I'm
they
going
heard
to
the
retract
case.
that.
Thank you, I'm sorry.
And we're going to retract
Catching
that
that.
motion, and we're going to ask for a second motion. Okay.
We accept the stipulation.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
All opposed, motion carries.
Thank you.
By Mr. McKinley, Mr. Ozunian, and Mr. Morris.
So the record will reflect the different panel on this one. Yeah.
Okay? Now, I don't have a withdrawal calendar. Do we have one? Very good. Thank you. Okay, we have a withdrawal calendar with 23 items, plus agenda item number 2, 8, or 5, 6, 7, 8, and 9. Is there any other withdrawals that we need to consider? Or is that it? That's it? Okay. Then do I hear a motion to accept the withdrawal calendar plus agenda item number 2, 5, 6, 7, 8, and 9?
I'll make a motion
To accept those items.
to accept those items.
Okay. And we have a second?
Second.
Okay, we have a motion and a second to accept the withdrawal calendar plus agenda items number 2, 5, 6, 7, 8, and 9. All in favor signify by saying aye. Aye. All opposed? Motion carries. Now, I believe we have taken all of the agenda items under consideration, correct?
Right, and no closed session today?
What's that?
No closed session today.
And no closed session today. So, is there any remaining items that the assessor would like to present?
None, just some encouraging news from the clerk. It appears like this has been a relatively mild filing season for assessment appeals. So,
Okay.
the assessor's office is currently actually working on the early part of the 2014 applications already. Have a large many of them resolved. So,
Does the clerk have an approximate number? Several hundred, probably. So under 1,000, maybe back to normal.
yeah.
Back to normal.
And we will keep looking at different opportunities to try to limit the people who say they're going to show up and then don't.
Good.
But
Panel,
we'll get
any
back
other
to your board
comments?
at the next meeting. And just a reminder that both in January and February, we meet on the fourth Monday because
Right,
of the holidays.
because of vacations and holidays.
So it'll be January 26th and February 23rd.
And we have a full board now.
Yes, which is wonderful. Thanks.
Good.
Tom.
Hearing no other comments to discuss regarding the Assessment Appeals Board of Tulare County for December 15th, 2014, this meeting is now adjourned.